stream is now running.
Thank you.
Based on a mandatory ground, it's two completely different things.
Just having a quick go at them, Appellant.
Court, rise if able.
Yes, Mr. Hodgson.
Please, Your Lordship. Prior to the short adjournment, I took the court to section 9 of the HH Housing Act.
Yes.
My lady junior has correctly reminded me that when reading subsection 6 of section 9, it effectively acts, it's at page, forgive me, it's at page 48.
Yep.
It's effectively a condition precedent. Because it says that this section does not apply if the court is satisfied that the landlord is entitled to possession of the dwelling house on any of the interposed mandatory grounds in Schedule 2. So, in my respectful submission, the court can't use that section to substitute a possession order on the mandatory ground. The wording of section 85 is slightly different.
Just pause a minute. The landlord section does not apply if the court is satisfied that the landlord is entitled to possession.
Yes.
Here, as I understand it, the district judge did not decide the landlord is entitled to possession on the mandatory ground, but that the landlord would be entitled to possession if a claim had been made on the mandatory ground.
Well, no, because she substituted a possession order on the mandatory ground.
Well, she substituted a possession order because she was satisfied that if the landlord had brought a claim on the mandatory ground, the landlord would have been entitled to possession. That's actually what happened?
No. She could only have made the order that she did if she was satisfied that the landlord is entitled, as of the date of the hearing, to possession on the mandatory ground. And that is contrary, in my submission, to the plain wording of subsection 6.
Right.
So there we are. So his Honour Judge Luba appeared to agree with that analysis, but held that under the authority of Manchester and Finn, the court retained jurisdiction under a liberty to apply. Now, I accept that where there's a suspended possession order, there is an implicit liberty to apply. The difficulty is, to what does that extend? At the end of the day, liberty to apply simply means that either party can apply to the court. And that makes perfect sense with a suspended possession order if there are issues as to working out the order. What it cannot do in my submission is entitle the court to entirely rewrite the order on different facts which arose at a later date. And effectively, well, exactly, substitute a mandatory ground.
Well, isn't that what the court did in Sheffield and Hopkins?
No, they didn't. They didn't impose a mandatory ground. They said they could. No, that's not right. Forgive me. They said they could convert the suspended possession order to an outright order on discretionary grounds, not on a mandatory ground. But they didn't. They weren't being asked to do that. In the end, the local authority took a step back and said, well, in fact, we just want an additional condition imposed.
Well, what you said was that the court couldn't rewrite the order on the basis of facts which arose after the date of the order. But that's exactly what the court did do, isn't it? In both Sheffield and Hopkins and Manchester and Finn.
I've expressed that badly. What I mean is rewrite the basis of the order. So it's one thing to convert a suspended possession order to an outright order on discretionary grounds. It's quite another thing to convert it to an outright order on a mandatory ground where the court has no discretion.
But I mean, if the landlord turns up with evidence that the tenant has been found guilty of receiving stolen goods, as in Manchester, the court can change the order, and use a neutral word, to reflect that fact which occurred after the date of the order, which was not related to the original ground on which the order was made, rent arrears.
Yes, but that's part of its exercising its discretion and as part of working out the order. What it can't do, I say, is to exercise its discretion to look at the new facts and say, we have no discretion now, we will substitute a mandatory order. And a problem with the respondents' arguments is really what's sauce for the goose must be sauce for the gander. Why cannot, if that be correct, if what the respondents' argument be correct, why should not a tenant who has been made subject to a mandatory possession order turn around and say, well, there's been a change of circumstance, I want to apply to vary the order. A typical example would be ground 8, where, as the court would be aware, the court must make a possession order if there are, for example, 8 weeks rent arrears at the date of the hearing and the date of service of the notice. Mandatory order is made, and then sometime before execution of the order, the arrears are paid off, or some of the arrears are paid off. Logically, if the respondent's argument is correct, there would be nothing to stop the tenant in those circumstances going back to court and saying, well, it's changed, I want the order to be varied, arguably rescinded, or to vary to a suspended possession order, because I can pay off what's left of the arrears on more reasonable terms. So I hasten to use the floodgates argument, but that logic would dictate that if it works one way, it must work the other. That would be unfortunate, not perhaps not for tenants, but it could lead to quite considerable litigation. The court would be well aware that the background to Manchester and Finn is that we were then in the whole territory of tolerated trespassers, where the courts were being very generous in seeking ways to avoid what was becoming quite a quagmire, because obviously it led to difficulties about enforcing tenancy terms, nuisance, repairs, succession, and so forth. So one can understand why Lady Justice Arnold would give a broad interpretation. That was very much the rationale at the time. It's just that the court will be aware. In Moseley, Lord Newberger held that all that jurisprudence is doubtful. He described it as creating an oxymoron, tolerated trespasser, but in any event didn't apply to tenancies under the 88 Act. And in the bundle of authorities, I don't, unless you wish, tend to take you to them now, but there's a passage by Lady Hill in Austin, where she sets out very helpfully the history and the development of the law relating to tolerated trespassers, and she says that it's a legal nonsense, an oxymoron. That may assist the court in these placing the Manchester and Finn in context. I'm not saying Manchester and Finn was wrongly decided. I've already conceded there is an implied liberty to apply. It's the extent to which that should be used. And one way it could be used is to say, well, yes, there is a liberty to apply, but it should be exercised by the court in a manner analogous to Section 9, the 88 Act, or Section 85 of the 85 Act. Because whilst Parliament must have, adopting the words of Lady Justice Arden, Parliament must have been aware that there is an implied liberty to apply in a suspended possession order. The corollary is also true. If Parliament was aware of that fact, it nevertheless brought in these statutory provisions, which are really quite clear. They're intended to increase the court's discretion, not preclude it.
So what was increasing the court's discretion?
I'm sorry.
What was introduced to increase the court's discretion?
Well, Section 9, its precursor in statutory terms is Section 100 of the Rent Act.
Yeah, I mean, this goes back to 1920, I think, these powers.
Yes, I believe so. It's even before my time. But
Mine too.
but yes, it was introduced in the context of I'm trying to remember the Lord Newberger's phrase, but it's an act designed to protect the rights of tenants, private tenants under the Rent Act and the Housing Act, and more recently social landlords and obviously secure tenants under the 85 Act. And Lord Newberger in Knowsley also gives a very very learned, very helpful description of how the law has evolved. Again, I don't propose to take you to that unless you wish. But it's clear that the purpose of Section 9 and this section 100 before, the Rent Act 77 before that, was to increase the protection of residential tenants, starting, as your lordship rightly pointed out, at the time of the First World War. The most recent case of my learned friend that I could find, and forgive me, I'm not on liberty to apply, is not especially helpful, but it's G&G at tab 8 at page 168. That was a family dispute over the family farm. The one brother, the claimant, brought a claim for promissory estoppel against his father and sibling, which he won, and it was awarded substantial equity in the asset. After judgment, the father lost capacity, and the other defendant's sibling took control. Essentially, what happened was that the lease to part of the estate was surrendered for a premium, so effectively an attempt to cheat the claimant. The issue was whether the court, having already been seized and having determined the claim, could deal with matters that have arisen as a result, or whether a fresh claim was necessary to be brought. The paragraph 15 of the judgment at page 173 states, in principle, I see no reason why it should be necessary to start a fresh claim in respect of a wrong done by procuring a breach of an order when the court is already seized of the original proceedings and may in any event be asked to make other orders in respect of the execution of that order. The position is a fortiori when, as here, B is already a party to the litigation. If the matter is sufficiently complex and or unclear, then the inquiry can be directed together with any necessary pleadings, disclosure, and so on. And then over the page, when I take you to paragraph 21 of the judgment, page 174, 3 lines down. For my part, whether or not it is right to imply liberty to apply in all orders for all purposes, I certainly consider that such liberty is implied for the purposes of enabling the party having the benefit of the order to complain that the party of obligations to perform under the order has not performed them, and to have the order modified to take account of what the performing party has done or not done since the order was made. So that's a 2022 judgment. Forgive me, I should have given the we just have the neutral citation, 2022 EWHC 1369 Chancery. But that is very different to cases such as Miss Kerr, where really if we're talking about a fresh cause of action, totally separate factual background, really has no relation whatsoever to our difficulties in paying the rent nearly 5 years previously. In those circumstances, by far the simplest and probably speediest solution for the social landlord is to bring a fresh possession claim. I've been a lot faster than I expected, but my lords, I think, unless I can assist you any further, those are my submissions.
Thank you very much, Mr. Hodgson. Yes, Mrs. Tweedy.
My lords, it's a privilege to stand before you today for the first time. I represent Poplar together with Jason Sharp and Callum Reid Hutchins, who are sat behind me today. I have submissions prepared on section 9, which is the main thrust of the argument. Briefly on liberty to apply.
Briefly on?
Liberty to apply.
Yeah.
And then I would like to end with a scenario which we've sort of touched upon already about why this, what I suggest is best for everyone. Unless there's anything in particular you'd like me to address first, I would start with section 9.
Right.
Now, I've got two propositions to backed up with some practical examples about why allowing a variation through section 9 is the right decision. And I had also written down what my learned friend has just said, what's sauce for the goose is sauce for the gander. We must be on some same page there. And I believe it's uncontroversial and agreed.
Well, I'm not sure that is necessarily right, is it? I mean, if the court were to make an order on a mandatory ground, so that section 9 is not engaged at all at the date when the order was made, then section 9(6) would seem to preclude
It does, yes,
a
sorry,
subsequent
absolutely.
exercise.
That's my whole point, yes.
So if, in Mr. Hodgson's example, possession is granted on a mandatory non-payment of rent for donkey's years ground,
Yes.
as I understand section 9(6), it is not open to the tenant to come back to say, well, I've just won the lottery.
That's absolutely correct. That's absolutely correct. That's my point's different. Same phraseology, different point. I apologise if I was confusing there. No, absolutely. You can't get an outright possession order and then on a mandatory ground and then come back and bite at it. No. But it is, I believe, uncontroversial that a tenant can apply to vary the suspended possession order.
Oh, yes.
And there's nothing in section 9 which says who can't use it. It's actually a power for the court. And I'd say the landlord, of course, can apply. But I wanted to give you 3 examples, just some running scenarios of where a tenant is using section 9. If I may start there before I get into the sort of meat of this section 9 provision. So, for example, you've got a suspended, example 1, you could have a suspended possession order on current rent plus £10 a week off the arrears, made on discretionary grounds. And then the tenant might lose their job and they can apply under section 9 to vary it to the minimum of, we believe, £4.53 per week now. That, of course, can happen. Second example, you might have an outright possession order based on discretionary grounds, grounds 12 and 14, and it's the daughter and granddaughter, or my Lord Lewison, the dog, or someone else causing this problem. And at the point of trial, they're still there, the problem's still occurring, the judge might find it reasonable to make an outright possession order on mandatory grounds. But 2 weeks later, the daughter and granddaughter or the dog might leave.
Sorry, I think you mean discretion.
Discretionary grounds, I'm sorry.
Yeah. So
It's my first
I've
time.
got rid,
Please bear with me.
I've got rid of the dog, so it
Got rid of the
won't
dog.
bother the neighbours again.
Yeah, I've got rid of the dog. Can you please now suspend this order to be a non-outright order on discretionary grounds? And yes, the court can. The third scenario is slightly different. Imagine you've got a suspended possession order based on current rent plus the £4.53 off the arrears of £3,000 based on discretionary grounds. Now the tenant gets a new job and hates having the worry of the CCJ hanging over them. The tenant can pay off the arrears and then apply to ask the court to discharge the possession order. And then it goes away. And I just wanted to sort of start there with looking at how the tenant can use this section. The second proposition before I get into the meat of section 9 is this. If you do what my learned friend suggests, the tenant who commits worse antisocial behaviour is in a superior position. And again, I would like to run through examples to demonstrate that. Scenario 1, we've got a suspended possession order based on noise nuisance, discretionary grounds 12 and 14. Sorry, let me start again. I've made my notes so truncated, I'm getting ahead of myself. We've got a suspended possession order based on rent arrears. The tenant then commits noise nuisance based on occurring in the property, and the landlord applies under grounds 12 and 14 to vary the rent possession order. I don't think it's in dispute by my learned friend that the court could then vary the possession order to an outright order based on discretionary grounds. Or Sheffield and Hopkins, which my Lord Lewison is familiar with, could execute the warrant based on new discretionary grounds. Yet let's look at scenario 2. Let's again look at a suspended possession order based on arrears of rent, and the tenant's son murders someone in the vicinity of the property. Obviously, much more serious antisocial behaviour. The neighbours witness it, and the absolute ground for possession is satisfied. Here, what my learned friend is suggesting is that the landlord can't vary that rent arrears possession order, and instead has to issue fresh proceedings. And I just want to touch very briefly upon a point here. And it's been suggested that it might be quicker to issue fresh proceedings. That is categorically wrong in my submission. It might be quicker to get a first hearing, maybe. But it's certainly not quicker to get a possession order at the end of a trial. And if I could just run through that practically for just one moment, if you indulge me. We have, with this new claim for possession, we have a first hearing. To get to that first hearing, my lords, you've had to have waited to the court to actually issue the claim. That is not a quick process necessarily at the moment. It might be a good few months when you've issued and have to wait to get your possession claim. You've
Just
sent
so
it to
I'm
court,
clear,
wait
do
to
I
issue.
understand that
Yeah.
you're referring there to the delays in the county court
Yes.
system in issuing claim forms?
Correct.
And
Yes,
help
my
me,
lord.
I'm out of date on all this. It's all now done through a centralised point, is it?
Yes, yes. Not in relation to possession claims. You often issue in the actual court.
Only on the bulk PCOL
Yeah. Oh, you often issue in the court. So, for example,
So,
people
so
do
you're
issue in
not
central
you're not
London.
subject to the 6 weeks delay in Northampton, which I understand is absolutely standard.
No, you might be 6 months at Central London County Court.
Right. Even worse. Okay.
And just to be clear, the delay that happens on issue at Central London County Court doesn't apply on the issue of applications.
It might, but in my instructions from Poplar, or it's not happening like that. No, because we've already got a claim issued, and this is an application in the claim. So of course, I can't give the evidence, but my instructions are not quite the same. No. So I'll take you back. So we've got the issue first. We then have a first hearing, and it's quite common at that first hearing that there's no defence being filed, and they don't have to file a defence. They can still take part in the hearing, which is unlike some other sorts of proceedings. But in possession claims, you have the first hearing, the tenant comes along, and what the court will often do is then require a defence to be filed and perhaps a reply. And then you come back to court for a hearing to see whether it's disputed on grounds which appear substantial. So has the defence got anything in it? And you often have those sort of a next stage. And at that hearing, you might not even get directions then if it's lasted so long of the argument about whether it's genuinely disputed on grounds which appear substantial. But sometimes you might.
But I'm not quite sure that I'm quite see where this is going.
Okay.
I take your point about the delay in the court system about issuing the claim.
Yes.
But if you go by way of amendment,
Yes.
not amending, you're
No.
turning, you're making a separate application to
To amend it.
vary the order.
Correct.
So does that not engage Part 55 at all?
It's much, let me answer sort of broadly. It's a much quicker process. What I'm going through now in perhaps too much detail, and perhaps I should just be a bit speedier on this, is it takes much longer to get to a trial on a fresh claim because you've got to go through all of these stages that I'm going through.
Right.
If you want to get in front of a judge for an application, you issue your application probably a bit quicker and you get in front of your judge. And then you don't have, at that point, fresh disclosure. You don't always have fresh witness statements. You don't have your sort of, is this genuinely disputed on grounds which appear substantial? You don't then have a CMC. You don't have then pre-trial review. You don't have to pay a trial fee. You don't have a full trial. You're here on an application. It's much quicker.
Are you restricting yourself to a mandatory ground, or are you making this point generally? Because let us suppose that you've got a suspended order on the ground of rent arrears, and as in Sheffield and Hopkins, the landlord wishes to convert that into an outright order based on some allegations of antisocial behaviour.
Yeah.
But not on the mandatory ground.
Yeah.
The tenant disputes the landlord's allegations, says, this is not me. You'd then have to go through all these steps, wouldn't you, in order for the judge to be able to resolve that question before deciding what order to make.
Not quite all of them, no, because I don't think you would necessarily get, it's not a new particulars of claim and a new defence.
Well,
You might get,
you'd have to have a statement of what it was the landlord relies on.
but it comes in an application.
Yeah.
It's not sort of a new pleading, and you're not then paying barristers to plead again. There might be some of the stages.
I mean, might it be said it's not very reassuring to be told that adopting your approach you can have procedural steps that might normally protect a tenant?
I would suggest, I would never be suggesting that. I'm not saying these steps are protecting the tenant, because you have, as you've seen in my skeleton argument, what I call the protections, which are many other procedural steps which protect a tenant. It's the practicalities of being in the county court, which I'm sort of referring to come to the point of, well, is it really quicker? You know, we all say, oh, it's much quicker. Is it really? And I'm sort of trying to bottom out that it is really quicker, not to lose that, so the tenant should lose anything.
Yeah.
But on this basis, the tenant loses the pleadings. You may say pleadings are a waste of time, but the court otherwise thinks they're a
I'm
good
a barrister,
idea.
I've never say pleadings are a waste of time. No, I mean, perhaps they do lose the pleadings. They do get the chance to see what's in an application form with a witness statement. And what I'm saying is they also are getting a fresh notice, they're getting the chance of review, they get the 12-month limit.
Well, I mean, in this case, the statutory notice served on the tenant will have given particulars of exactly what it is the landlord relies on in order to support the mandatory ground.
And if we're back to a mandatory ground,
So the tenant knows what the case against him is.
and if we're on a mandatory ground, there's been, in most of the cases, a criminal conviction. There's been criminal proceedings.
Yes, but as in this case, the tenant is not the one who's being convicted.
Correct. But that won't always be the case.
No. But anyway, notice is given in the statutory notice of what it is the landlord is going to be relying on.
So where I was at was just on the scenario that why it's essentially the tenant is advantaged by worse criminal behaviour.
Yep.
Because you can't apply to vary. And I would say about that as well, in this scenario, the tenants not only, as HHJ Luba said in previous cases, had a warning shot across the bow of the notice. The tenants also had behaviour so serious, even if it's rent arrears, still so serious to justify a possession order being made already. And I would suggest that this behaviour is so serious that Parliament has legislated to remove the court's discretion under Section 9. That was my introduction, and I'm of course conscious on the time. I would like to move on to the specifics of Section 9, if I may. And there are 5 points I'd like to make here. The first is an interpretation point. The second is the absence of the word vary. The third is the order variable? The fourth is the exercise of the discretion and the mandatory ground. And fifth, I would like to just then look at a bit of a stand-back analysis for a moment.
What's the fifth? You stand back?
Stand-back analysis. I just want to stand
Right.
back for a moment and have a look at this provision, because it's very easy when you have prepared extensively to come to the Court of Appeal to get very bogged down.
Yeah.
I just want to come back out.
Right, so interpretation.
Interpretation. Lord Newberger and Knowsley, when looking at Section 85 Act, if we could pull it up, it's page 278, paragraph 97, and that's in your authorities part of your bundle, which I think is your second bundle. And that's right at the bottom. And this is Lord Newberger looking at Section 85 at this point, although in this case he was looking at assured tenancies as well.
Yeah. Give as much flexibility as possible.
Sorry, I'm just going to give, just bear with me just one moment. Apologies, it's actually paragraph 68, 271.
Yeah.
When the Lord Newberger here is quoting some cases from some points from Kay and Lambeth, which was originally made in Baker and Turner, and the point is this, that the rules of formal logic must not be applied with too great strictness to legislation conferring security of tenure on residential tenants. But that's quite extreme. But that's what Lord Newberger was concerning himself with in Knowsley. I suggest you don't even need to go that far. You simply need to give a purpose of interpretation to the Act. Or perhaps even just look at the strict wording of the Act, of the section. I don't propose to address you in any further detail as to why a purpose of approach is required or why you should be looking at the practical effect of your decision. You have those points in my skeleton argument, unless there's anything in particular there that I can help you with. So that's issue 1 done. Issue 2, the elephant in the room. We're all talking about varying a possession order, but it doesn't say the word vary. But I suggest that's no problem at all.
Sorry, what doesn't say?
Section 9 doesn't say the word vary. Section 85 doesn't say the word vary. But that's not a problem. Essentially, the consequence of the correct interpretation of that act is a variation. But I want it to be clear that it doesn't say the word. And if you were minded to agree with me on that point, I would say you would be in good company. It was certainly Lord Brown-Wilkinson's view in Burroughs at 144E.
Well, I think Lord Newberger says it too.
Lord Newberger says it, Lord Mance says it, Lord Justice Ward and Finn says it. But I wanted to get it out there. The third point, and this is where we're really sort of coming to it,
Well,
is...
I think you probably are entitled to say that the predecessor legislation, going right back to 1920, has always been interpreted as giving the court power to vary orders of this kind, and Parliament in legislating must be taken to have understood that that was regular court practice.
That could be one strand, and to add to that, Section 89 of the Housing Act 1980 talks about the word vary, says the word vary. One strand, the other strand, the way I've argued it, is just that it's a consequence. It doesn't need to say the word, but yes, I agree. Issue 3, we've got a suspended possession order. Is that order, now we've got over the word vary, is that order variable? Is it changeable? For that, I looked at Section 9 in detail. And the first thing to look at there is Section 9.2. Well, has it been executed? No. The tenant's still in her home. When I first started doing this sort of work, the point that used to trouble me is 9.2. Can I postpone the date? How am I postponing the date? Well, it doesn't trouble me anymore because you've got a date in 2017 for which possession must be given, and you're postponing it to 2023 or 2024.
Yeah.
And Regan looks at that, and Austin talks about that lots. Now, the third point on issue 3 here, so when we're looking at is this order variable, and this is just meeting my learned friend's point, does Section 9.6 mean it can't be used? Can't be varied? And I say no, it doesn't, and it's quite clear it doesn't. And I'd like to address you on some alphabet-y spaghetti ABC here. So I can't say 1, 2, 3 any more times without us all getting confused. So is it variable? We're looking at 9.6, point A. Just wait and see if my lord is pulling it up. The point of this section is to prevent courts suspending orders in the most serious cases where parliaments said they can't. It's not to prevent mandatory orders being made. Point
If they
B.
are made, they won't be made under this section.
If they are made, they won't be made under this section, and they won't be varied under this section, as long as they're absolute grounds, mandatory grounds.
Yes, I'm taking out of your course, but
All right.
this is, I think, the bit that sort of worries me.
Okay.
So, suppose you had come to court originally, relying on the mandatory ground. Plainly, no order would be made under Section 9, and there would be no power to make an order under Section 9.
So you come to court originally asking for possession as the landlord under a mandatory ground,
Yes.
right? Sorry.
You get your possession order, there's no power to make an order under Section 9, no order is made under Section 9.
Right.
Now you come to court later in circumstances where an order has been made under Section 9. And what you want is not a new order under section 9 that you can't have. You want to get rid of the order under section 9.
Right.
So in that sense, section 9 might not help you. You can't have an order under section 9 because you are relying on the mandatory ground. What you want to do is get rid of the existing order under section 9, discharge it. You don't want an order under section 9 at all. And you can't have it because you're relying on the mandatory ground.
I'm not sure I'm following the problem.
Well, in cases you've
I
referred
apologise.
to, cases you've referred to previously,
Yeah.
where an order has been made on a discretionary ground, and then the court is being asked to exercise discretion again, a new order can obviously be made under section 9
Yes.
because there's no bar under section 9(6).
Yes.
But what you're asking to do
Yes.
is not asking really for a new order under section 9 because you can't have it. Because section 9(6) says you can't have an order where the mandatory ground applies. You want to get rid of the existing order.
No, I would say I can understand that analysis. That's not quite right. That's not what I'm saying. I'm saying I've got an original order, and you said original order on mandatory grounds, but
No,
it would
no,
be
no,
discretionary. I think so. If I've got my original order on a discretionary ground, and I've got my new basis for possession being a fresh mandatory ground, I have to go if I want to sort of, unless I want to start new proceedings, I have to use my original discretionary order to sort of to bite at that order, to change it into.
Do you say you can have a new order under section 9?
I'm not asking for a new order. I'm asking for a variation of the order. This is is it a new order? Is an important question, I think. Because
Well, I think you're saying the only ground on which the court has ever made an order for possession is under section 9,
correct.
because the only order it's ever made has been on discretionary grounds.
Correct.
It could now make an order on mandatory grounds, but that's not what you're asking
No.
it to do.
Correct.
You are asking it, in the light of this new material,
Yes.
to vary the order under section 9
Yes.
by discharging the conditions of suspension
Yes.
and postponing the possession date from the original date in
Correct.
2017 to
Yes.
whatever the date is now in 2022.
To a fixed date with no further conditions.
So let me come to that point.
Yeah.
If what you want is an order postponing, what is the power to make that?
If the underlying possession order is discretionary, made using section 9, you have the power to change that order at any point to execution. If
The new order is not under section 9.
so that's what I'm going to come to it. The new order, you are biting at the old order, you are varying this old discretionary order. The court then that's the 3 stages I'm going to. Can you? Say you can do it, the court has to exercise its discretion under 9(2), and then I would say at that point, the court is then looking at a mandatory ground for possession. Should I exercise my discretion to vary this order? Yes, I've got a new mandatory ground for possession and I'm varying it to be
But
an
how
out-
can it exercise the discretion under 9(2) if 9
if it's lost under
section 9 doesn't
9(6).
apply
I-
because it's a mandatory ground?
Because that comes first. Because the exercise of the discretion essentially comes first. And let me just say one more point on this and then something else. So it is, as long as the original order is discretionary, the court's discretion continues to be engaged. 9(6), which I'm going to come to, 9(6) looks at what happens later, I would say. It's still exercising its discretion under 9(2). But to vary, and then once the court is satisfied that the new ground is made out, the only order that can be made is an outright order. And perhaps it's a little clunky. It's the point which I've been thinking about a lot. And that's why I want to take you to a stand back analysis at the end. I say it works with the purpose of an approach. It works following the line from Sheffield, moving on, executing Manchester and Finn, moving it on discretionary. Now we've got these mandatory grounds, moving it on mandatory too. But perhaps it's a little clunky, and I will come back to you on a stand back analysis on that if that's all right. I say it works, but I hear entirely your point. I've been thinking about that a lot. So what I was looking at is section 9.6, and all I'm looking at now is getting at the original order. Is that original order variable? Because my learned friend says it's not because of 9.6. But I said that's what I've said. The point of 9.6 isn't to do that. And my second point on 9.6 is this. And you might have to bear with me on this one a little. If it's right that 9.6 excludes a variation on new absolute grounds, given we have these absolute grounds in not only the 88 Act, but also the 85 Act, I'd expect to see a shadow provision in the 85 Act under section 85. There is no shadow provision. There is no same point. That's at page 27 if you want to look at it. And now, of course, section 85 didn't originally have this provision because there were no original mandatory grounds for secure tenancies under the 85 Act, whereas the 88 Act was different. But when these absolute grounds were brought in, bearing in mind they were brought in after Finn, so the court knew it was being 9.6 or 85 was being used in this way, if 9.6 was meant to exclude using mandatory grounds in this way, then it would have been legislated for in section 85, but it wasn't. And if you look at section 85, it's clear that it's looking at postponing discretionary grounds up until execution. So the point doesn't work. My learned friend's point doesn't work. And C, the third reason why it doesn't work is the wording of section 9.6 is such that it only prevents section 9 being available once the court is satisfied that the landlord is entitled to possession on a mandatory ground. It puts the cart before the horse. At this stage, all we're looking at is whether the court can vary. 9.6 does not prevent that.
So just to go back to your point on section 85, I think you're saying section 85 and section 9 are supposed to work in tandem depending on whether you're public sector or assured tenancy. It would be odd if a power that was available under section 85 was not available under section 9.
Absolutely, because it's just not the correct interpretation. It's a misreading. It's not right, what my learned friend is suggesting. And that sort of backs it up.
Is there not necessarily a distinction because of section 9.6?
No, it doesn't do what my learned friend says it's doing. It's not saying on an original, if you've got an original mandatory ground, 9.6 doesn't work. If you've got an original discretionary ground, the court's been satisfied on a discretionary ground, 9.6 does not stop a variation there. It just doesn't on the wording of it. And if it did, I would want to see it in section 85 because there's mandatory grounds there too, the absolute grounds, bearing in mind they were brought in after Finn, like I said, but I don't see it there. It doesn't do that. Now, the fourth point on section 9, and this is, my Lord Newey, I think, where you might be having a little conceptual difficulty, and I understand the conceptual difficulty. It's the sort of, once, I would call it, you're in at the order. We've got the suspended possession order. Once you've got the key to the door, section 9 is essentially the key to unlock that suspended possession order. And perhaps so is liberty to apply, but we'll come to that. Once you've sort of unlocked the order, what then happens? Well, Sheffield and Hopkins, Manchester and Finn, they were all further discretionary grounds. So this wasn't a problem because that discretion was sort of back in play. But here where it's not in play on a new mandatory ground, how does it all fit together? And I would say it happens this way. The court, once it's in at the order using section 9, once the door's unlocked, the court probably still at that point has to choose whether to exercise its discretion. So I'd been sort of going straight from looking at section 9 to straight into the mandatory ground. But perhaps there's a stage in between. And perhaps a court might say, although I can vary this order, I'm choosing not to in this case, irrespective of what you've got coming on mandatory discretionary, it's still a discretion of the court to vary the order. That's not really how it's been put sort of in the other cases. But I would say at that point, the door's unlocked, the court's looking at the order, shall I vary it? And at that point, if you've got a new the court says, yes, I'm going to exercise my discretion here. And at that point, if you've got a new discretionary ground, the court reapplies section 9. Is the ground for possession made out? Is it reasonable to make the order? Shall the order be suspended, postponed, or outright? It's a sort of reapplication. But when you've got a mandatory ground made out, that's all that the court needs to be satisfied on. The new fresh ground, is the ground made out? You know, there might be arguments on Human Rights Act. Is that ground made out? If it is, the only order I can make now is a mandatory outright order for possession. So, and I appreciate it might be a little clunky, but I think that's the way I can best describe it. And if I could say 2 more points about that. At that point, the court under 9.3 is looking at conditions. Of course, it can't be reasonable or fit to impose conditions there because the new ground doesn't let me. And I would say it's also, the court's looking at what's just in exercising that discretion. And as I set out in my skeleton argument, it's inherently just, given all of the protections, that the order can be a mandatory ground.
Now, let's suppose you turn up with your new ground. Tenants complying with all the conditions relating to rent arrears, and you say, "Look, Judge, I now want to turn this into an outright order and enforce it." You're making your application, you say, under section 9. So the court has a discretion. Can the court say, "I'm not going to exercise my discretion, bring another action"?
I think so. I think so.
So there is a discretion in
Whether
the
to
court.
do something with the old order.
But you go on to say, well, if the court decides that it will exercise its discretion,
Yes.
the fact that a mandatory ground either has been or could be established is such a powerful factor
Yes.
that in reality there's only really one way that discretion can be exercised.
It would be unusual.
Is that how you put it?
Not quite. I get to the
Okay.
point of the exercise of the discretion, yes. And I would say it would be unusual. Would it be a proper exercise of a discretion not to allow it? I don't know. There might be some scenarios that it might. But at that point, upon exercising the discretion, the only order that can be made is an outright. I say the court is deprived at the point of being satisfied that the new ground is made out. The court is deprived at that point. And I know.
I suppose this is another way of sort of expressing the worry I have. And I quite see if you have a real discretion under section 9, fine, sort of. But there's a danger of trying to have it both ways, saying, look, we're in section 9, the court has a discretion. And then saying, no, we're outside section 9 because there's a mandatory ground.
I hear what you're saying, my Lord Newey. I hear the point that you're making, and it's, as I've said, something I've thought about a lot myself. And the way I've analysed it is that it is unlocked. I don't think it's really in dispute. It's not really in doubt that you can unlock it using Section 9, and it's then at that middle point, the court's exercise of the discretion, that comes before the new mandatory ground. And once you get the mandatory ground, then the discretion is sort of, it's a re-exercise, and the discretion is stripped. And an analogy I was thinking of, it's hard to think of an analogy. I'm sort of thinking of like a permission to appeal, plus the rolled up hearing. You sort of, it's not quite right, but if, you know, you can be asking for permission to appeal and have the rolled up hearing at the same time, much like you sort of exercising the discretion and then having the answer at the same, there's the second order, the variation at the same time.
I mean, I suppose trying to sort of muddle through it for a moment. So the landlord comes to court, says, I want to vary, I'm relying on Section 9. So the court says, okay, we see you want to vary, Section 9 does indeed confer a power to vary. And then the landlord says, well, here I've got this mandatory ground. And the court says, oh, I think you're right about that. So the court is then satisfied that you're entitled to possession on the mandatory ground. On the face of it, at that point, 9(6) says you can't make the order under Section 9. If you're going to make an order, it has to be on a different basis.
I hear that, yeah, but I say it comes later. It comes later. The point at which the court is satisfied comes later. It's the second.
It has to be satisfied of it before it makes the new order. So what order has it made before it's satisfied?
It has decided to exercise. The judge has decided to exercise her discretion.
So she thinks she's got a discretion, and then you say, no, she hasn't.
She's exercising that discretion, and in exercising it, the only thing she can exercise it to is outright.
Where does Section 9 say that?
It doesn't say any of these words necessarily, as we've said, but what we're looking at is a purposive approach to this. We're looking at the court exercising discretion up until execution on a discretionary ground. And how does the court do it? And that's why I call it clunky. Because I hear the point, but I would say it varies it. It's allowed to vary it, because you can get in at it, unlock it. It chooses to, the judge, she chooses to, and then at that fresh exercise of discretion, the discretion is stripped.
Why should the judge choose to exercise the discretion before being satisfied that the mandatory ground applies?
It's a tricky question. The judge can, the judge knows what's coming. But I could imagine, and as I said, I've been thinking about this, perhaps there's a scenario where the judge says, even though I know this new ground is coming, I'm not going to look at that yet, really in depth. Because what I'm going to do instead is say, no, this possession order is nearly 6 years old. The tenants complied with their rent arrears for 6 years. They're £2 now. No, I'm not going to exercise my discretion under 9(2). However, I would like to just address you on this fifth point, if that's all right, and that's the stand back analysis, if I may.
I'm sorry to interrupt you, Mrs. Tweedy. Can I just go back for a moment? The order for possession is not made under Section 9, it's made under Section 7. That's what gives the court the power to make the order for possession.
That's right, sorry.
What the court is doing under Section 9 is suspending that order and or imposing conditions on the suspension.
Yes.
So when you go back to court, you're not asking the court to make an order for possession under Section 9.
No.
You are asking for the court to allow the order made under Section 7
Yes,
to be enforced.
that's right. Which is different. That's right. And which is why it sort of doesn't come in, because you're not making, and I've thought about this, is it making a new order for possession? Because in Finn, the judges talk about fresh order. And I don't think that that's what they mean. I think in context they mean a variation of the order. Like you said, it's not making a fresh order there.
I follow how that's put. Can I just see how it works here? Where do I find the possession order?
Let me just.
I think it's exhibited to Miss Mallock's. It's exhibited to Miss Mallock's witness statement, I think.
112. Tab 15.
It's page 176, I think, isn't it?
Oh.
That's the original suspended possession.
Yeah.
I suppose
That's
that's
the
what
suspended order.
we're concerned with here. So
If 112 is that it was varied by His Honour Judge Luba under the slip rule to make some sort of, it's 112, I would ask you to.
but in terms of understanding the structure, my lord says, so there's power to make the possession order under section 7, and then it's suspended under section 9.
So I think it might be helpful to actually look at 176 because it illustrates our starting point. So this is the 7th of February 2017, and paragraph 1, defendant give the claimant possession of property on or before. So that's the section 7.
Yeah.
And then you've got paragraph 2, rent arrears. Paragraph 3, not to be enforced so long as. And so that's section 9 too.
So on this thesis, come the point where you come back with your mandatory ground, you don't need to ask for a new order under section 9. You merely need to ask that paragraph 3 goes, leaving you with the possession order under section 7.
So you're not asking for a new order under
Plus you
section
postpone
7.
the date.
Yes, you're not asking for a new order under section 7 or section 9. You're asking the court to change it using section 9.
Do you?
Yes, the answer is yes.
But I'm not sure. So, if you say, well, section paragraph 3 you should go, you're not then asking for a new order under section 9. You're saying the court no longer has power to suspend or postpone under section 9. On the face of it, that leaves you with paragraph 1, which is the original possession.
But
That won't do, you say, because you have to put in a new date.
But why can the court not do that anyway? I mean, suppose an injunction, a mandatory injunction is required, and it requires compliance by a specified date, and the respondent to the order doesn't comply by that date. It's common to make a further order specifying a second date.
So, again, injunction sort of, in my mind, went more under the liberty to apply sort of route. When you've got a final mandatory injunction.
It's about the court's power to enforce its orders, isn't it?
Well, I can't believe there's any dispute about the power of the court to change the date by which possession is given in the same way that you can change the date by which you have to carry out an order of an injunction kind.
Can I just think about that a moment? Because essentially, you know, a possession order is essentially a final order. And so the court wouldn't then be usually looking to sort of then change that without some way of doing that. Although a possession order is a continuing order. It's sort of continuing in the sense that it's still, you know, is live because the parties have to do things under it, much like an injunction.
I think that's what exactly, because it's although historically claims for possession are different and special, looking at it through contemporary eyes, one can say that this is a form of mandatory injunction. And if you strip out a non-enforcement provision so as to allow the mandatory injunction to be enforced, on one view, it's simply the court enforcing its order.
I hadn't analysed it that way, and it hasn't been analysed that way previously in the courts, but I can see the force in that argument. I don't even know if you'd need to amend the date, coming back to that point. Could you not just then get the warrant?
Well,
That's what I was...
what you're doing, I think, as my lords have said, is you're not asking the court to make another order under section 7.
No.
The court's made that order.
Yes,
You're asking for the court to exercise its power under section 9
yes,
to alter paragraph 3.
yes,
So section 9 at that stage is engaged.
yes,
And at the time when section 9 is engaged, the court still has power to postpone the date for possession. So in exercising its powers under section 9, the court is discharging paragraph 3 and substituting for the 7th of March 2017, the 2nd of March 2022.
yes.
I think that's a different
A
analysis.
different analysis. My sort of, and I'm obviously not going to argue against it, but my question would be why and how, and that's that. I can, if it doesn't have the new information, why and how is the court doing that? But using section 9. So if I can pause there for just a moment.
Right, we're going to look at your stand back analysis.
Another analysis that might work. I understand it's a phrase used by my former head of chambers a lot, Nigel Jones, KC. So if for whatever reason you're sort of struggling with the perhaps a little clunkiness of section 9, and perhaps you're not satisfied in relation to a purpose of approach, or perhaps you sort of the other analysis doesn't work for whatever reason. I thought of it in this way, and I just thought it was important to mention it. Perhaps this isn't new, fresh grounds for possession. Perhaps it's just new information, like Sheffield and Hopkins. And the court retains its section 9 discretion. So it's not a new notice, and it's not a new ground. But I would say that argument, that point, disadvantages the tenant. And I don't think you should go for it.
Well, I think your problem with that is that District Judge Bell said she didn't have discretion.
Yes, that's why it's not
So
the argument in the
If
case.
you're right about that, then wouldn't it have to go back to her to decide whether to exercise that discretion?
Yes.
Because what she says in 39, if the grounds of variation of discretion in section 9 is again engaged, the court would need to consider whether to postpone or suspend. But where a mandatory ground is arrived, the court does not have to go on to carry out that further exercise.
Absolutely, it would be you could very unusually exercise the discretion, but you don't have the information before you here in the Court of Appeal. But it would be a fresh exercise, which is why I'm not running it as a submission. I'm sort of just wanted to raise the point when, having deeply analysed section 9, I thought it might be appropriate to just tell you about this as a stand back.
But I think the way Judge Luba looked at the first appeal was it was all about jurisdiction. It wasn't really about anything else.
Yes. But, my lords, in this particular appeal, the stand back analysis isn't the appropriate one. Not only for the reasons you've given, my lord, but also because that, I would say, is a disadvantage to the tenant. Now, I would like to just explain briefly why. I would say where you've got these sort of, where you essentially meet the criteria for the new absolute grounds, it's almost always going to be reasonable to make an outright order on the exercise of the section 9 discretion. But the tenant will get no new notice. The tenant will get no fresh review. And the tenant won't have the 12-month limit. So if you were sort of minded to say the analysis was something that the judges below you haven't analysed it in this sort of stand-back way, I would say that's actually a disadvantage. It shouldn't be the analysis, and it's actually a disadvantage. And I actually even thought imagine you could even then get a scenario where the landlord tries to use the mandatory ground, reviews it, says it won't use the mandatory ground, but then brings it in through the back door in this way anyway. So those are my submissions on section 9. Just to meet one point, my learned friend suggests that Finn was decided in the era of tolerated trespass. Well, in Finn, as you're aware, there was a suspended possession order and the tenant had complied with the order. In the circumstances as it was when Finn was decided, that wouldn't give rise to tolerated trespass. It would at a later stage when the law moved on, but at that point, there was no tolerated trespass. So I just wanted to sort of knock that one out. Now, where are we at? I'm conscious of the time. There's some brief points I'd like to make on liberty to apply, and then I would like to just sort of conclude to say why it's in everyone's best interests to do what I'm suggesting you should do. So, if section 9 expressly doesn't allow the variation in the circumstances of this case, it expressly says no, then I can't imagine an uphill battle to say liberty to apply can do it through the back door if it's expressly excluded. However, at that point I would simply rely on Lady Justice Arden in Finn. Second point is if section 9 doesn't sort of expressly exclude it, but it just perhaps doesn't deal with it, doesn't quite fit, I would say liberty to apply in those circumstances isn't ousted by a parliamentary overlay. The court would still retain its liberty to apply. And the other key to the door would be the liberty to apply there. And at that point, the court would be considering again whether to re-exercise the section 9 discretion, as I set out in my skeleton argument. The third point is if I win on section 9, I don't need liberty to apply, but some might say I'd be mad not to rely on the points made by His Honour Judge Luba and Lady Justice Arden and Finn, and so I do. One point on that, and do you step a step too far with your final point? We're right there. If there is no liberty to apply, which is inherent in the order, although my learned friend conceded that, I would say you can amend the order under the
Well,
slip
he
rule.
conceded there was liberty to apply,
Yes,
but what he didn't concede was that it could be used for this
the
purpose.
extent. Correct, my lord. But I'm just talking about this first stage now, not the extent. You could, I would ask you to amend under the slip rule. You can do that under CPR 40.12 and 52.22A.
I'm not sure that we can amend somebody else's order under the slip rule, can we?
I
Unless
thought-
we're satisfied that it was left out by error.
I thought, yeah, 52.22A might give you the ability to do that under the slip rule if it's by error. And I would suggest that perhaps in those circumstances, guidance is issued to county court judges so they know they have to put liberty to apply into their orders, because that's not common.
Yeah, I mean, the slip rule is for having made mistakes, not for second thoughts.
Right. The guidance point still stands. To end my submissions, my lords, I would just like to suggest that it's in everyone's best interest, in the circumstances of a claim to possession, to allow the possession order to be varied in the way I've suggested. And I'm going to mention the court, the landlord, the neighbours and the tenant. The court is already overburdened. An application in proceedings is less work and less engagement than a brand new claim for possession And we're back then to there will be less time and more cost effective for everyone involved. You know, the judges, the court staff. In relation to the landlord, in the facts of this case where it's a mandatory ground, and we've already got a possession order. The landlord has already gone through that process. The warning shot's been done, the possession order's gone, and now we've got new information again. And the landlord's already waited for a criminal conviction. And it's a quicker and cheaper way to protect the landlord's stock, because who knows what the antisocial behaviour might be. And other tenants. Now, as to the neighbours, this isn't antisocial behaviour in a vacuum. The neighbours may have been witnesses in the criminal proceedings already and living in fear. It's right that this should be dealt with as efficiently as possible.
Well, I'm sorry to interrupt. I'm a little unhappy with this line. There's no evidence before you of ongoing problems in the area.
No, I think this is just to justify Mrs. Tweedy's overall approach. I don't think it's suggested there is ongoing, at least there's no evidence to show there's ongoing.
And indeed,
antisocial behaviour
district
here.
judge specifically found that other allegations were not made out.
Yeah, it's not about specific facts of the individual case, it's about the generality of the approach.
So,
My lord, just to correct one point, I wasn't counsel previously, but I understand it's that the judge didn't make findings, as opposed to she didn't find it to be made out. I think she didn't make findings, as far as I understand.
Right.
Now, the last point after talking about the neighbours is the tenant itself. I would suggest it would cost the tenant less to defend an application, and as opposed to a whole brand new trial with a trial fee and everything that comes with that in relation to a fresh claim. And what we end up with is 2 possession orders. I've touched upon it at all in orally, but that has the potential to be very confusing, and there's no disrespect whatsoever intended there, because we've been before the court today, and this court and the Supreme Court has considered on many occasions what a possession order means and how this legislation works. It wouldn't be in anyone's best interest to require 2 possession orders when, frankly, in my submission, Section 9 works, and so does liberty to apply. Is there anything else that I can help you with?
Thank you, Mrs. Tweedy.
I'm very grateful, thank you.
Yes, Mr. Hodgson.
yes, I apologise for the interruption. In my respectful submission, the wording of section 9 couldn't be clearer. Subsection 1 says, subject to subsection 6 below, the court may exercise the powers to adjourn and so forth. So you don't need, it's not a question of getting past first base and then somehow subsection 6 doesn't apply. You don't get to first base if it applies. So I would invite the court to adopt the reasoning of His Honour Judge Luba, when he says that really Section 9 has no application at all. I wasn't, and I apologise if I didn't make myself, well, I obviously did not make myself clear. I'm not suggesting that a tenant can apply under Section 9 when he's subject to a mandatory order. I'm just saying if there's an overall power under the liberty to apply for anyone to do so, then the floodgates would be open. You clearly cannot do so under Section 9. The wording of the order finally made after His Honour's amendment is at page 81. The court will appreciate that, unlike an injunction, an order made under the 88, indeed the 85 Housing Act, should specify the ground upon which the order is made and whether it's a mandatory or discretionary ground. And we can see at paragraph 1 under it is ordered that this order is made on a mandatory ground, Housing Act 1988, Schedule 2, ground 7A. There's no question of the original possession order being
What was it that was corrected? Do you know? So I don't think we've got the original.
Good question. I can't remember.
It's just the phrasing. My lords, it was just the sort of phrasing of the way it was expressed and typos. It wasn't anything substantial.
And finally, although it's not especially important, in respect of the findings of district judge.
Before you do,
I'm
can
so
I
sorry.
just understand, can we get back to 176, the original order?
Yeah.
Just so I understand your position on this. So back at 176, paragraph 1 will have been made under section 7, presumably.
It doesn't state the ground upon which it would have been ground 10.
Yes. And you say you're required to specify the ground, and show my ignorance, where does it say you're supposed to specify the ground?
I think you specify the ground in your notice. You don't have to specify the ground in the order.
My lord, it's just sort of there's been over the years many sort of forms of practice, and often the box they'll want to specify in practice, but I don't believe there is a requirement.
There was a case, Bay Green and Grill.
Bay Green.
It's become the practice in county courts ever since.
Yes, that's
That is because if you don't know whether, again goes back to section 9.6, if the court doesn't know whether possession orders been made on a mandatory ground or not, they don't know whether they have jurisdiction to hear an application to suspend.
Then there is the oddity, this order doesn't actually name the ground.
No, but it's quite an old order.
Sorry.
It's an old order
Yes, I see.
from
Okay.
17.
So you've got paragraph 1, presumably made under section 7, and then paragraph 3 plainly relies on section 9.
So where does your lordship get section 9 from?
When it says the order is not to be enforced so long as the defendant pays.
Oh, I see, yes.
That has to be a
Yes,
section 9.
apparent section 9. I apologize, yes, that's right.
So suppose that the landlord comes along under section 9, comes along to the court and says, actually, things have changed. It's no longer appropriate to have an order under section 9. In fact, there's no power to make an order under section 9. Would a conceivable solution be to delete paragraph 3 and leave paragraph 1?
But that would be really a there were a number of objections, I would say, to that. I mean, the court granted the suspended possession order on ground 10. That was its finding. That was the order it made. Now there's this totally separate factual issue, and the court is being invited to vary the original order, but without specifying what the new ground is. I appreciate I can't explain that very well, but it's unsatisfactory. It's much more satisfactory in my submission that there is a fresh order, a new order, whether it's a variation of the original order, or however it is expressed, which makes it clear this is a mandatory order, this is the ground upon which it's made, and
That's done for convenience. That's not a statutory requirement, is it? I mean, just take a rent arrears case. Claim for rent arrears, claim succeeds, order suspended on terms that tenant pays current rent plus X pounds a week off the arrears. Tenant doesn't pay. Landlord goes back to the court and says, forget section 9, this tenant has just not paying, let the possession order go. And the court says, all right, tenant's not paying, has made no effort to comply with the conditions, we'll delete the condition, let the order stand.
Yeah.
There's nothing wrong with that, is there?
There's nothing wrong with that, but that's using section 9, and that's changing a suspended order to an outright order on a discretionary ground. But what the landlord cannot do, I say it's plain from the wording of the section, is to say, I've hit the jackpot. I don't mean to say that. I've got an unanswerable case here. He's been convicted of a serious criminal offence, and here's the certificate of conviction. It's within the locality of the property. I've served the requisite notice. He's had an opportunity to seek a review, and you have no choice but to make a possession order.
And you say, cool, the landlord can't ask for a new order under section 9 because section 9(6) bars any further order.
Well, absolutely, yes. Yeah.
I'll ask you about another way of looking at it, and again, looking at this 2017 order is a convenient way of framing the question. So as we've discussed, paragraph 1 seems to be an order under section 7, and paragraph 3 an order under section 9. Is one way of looking at what the landlord was trying to do in this case is to say, well, it was tantamount, it wasn't expressed this way, but it was tantamount to revoking paragraph 3 on the grounds of a subsequent change in circumstances.
Well, that's not the way it was argued.
I know it wasn't. I'm asking you if that's a tenable analysis, and if you let me be clear as to my question. If your submission is that that's legally untenable, please tell me why not.
Because the order in 2017 represents a judicial finding that it's reasonable to make a possession order and it's reasonable to suspend it, and on these terms. And on a particular ground, in this case, ground 10 of the Housing Act. Years later, landlords coming back and saying, I have a totally new set of facts, a totally separate ground for possession, and it's not adequate to simply say, well, the existing suspended possession order should be altered without reflecting the new ground for possession. But the same issue same problem would also arise, because if that's made on an application, then what the landlord is saying is, I have a new mandatory ground, and I'm making an application under section 9 or under the implied leave provisions. But he can't do it under section 9 in my submission. Whether or not he can do it under implied leave to apply, you've heard our arguments on both sides on that. I won't repeat them. I say that if the liberty to apply extends to effectively rewrite the order, the original order, then there is a risk of opening the floodgates. It makes sense where Parliament has set aside a statutory provision to deal with these cases, that any exercise of applying under the liberty to apply, A, I would say usually would be unnecessary, but B, should be exercised by the court in accordance with the statutory scheme.
Yeah, well, I appreciate your point that the procedural form shouldn't disguise the reality of what's going on. And I take your point that the reality of what's going on here is the landlord's trying to invoke a new mandatory grantor, which has arisen subsequently. I fully get that. But again, just thinking in terms of the language of the legislation, one of the words that's used in section 9, subsection 2 is stay. Now, one's got to be careful about trying to analogize between statutory language and the inherent jurisdiction of the court. But if we think about ordinary procedural circumstances in which orders are stay of execution pending appeal, for example, it's not uncommon to have a stay and then the stay is lifted.
Yeah.
And it might be because of non-compliance with original terms and conditions, or because there's been some relevant change of circumstances, whatever. And the point of that observation is to lead up to this question. Would you accept or dispute that the language that we see in section 9.2, stay, suspend, postpone, all by implication carry with it the power of the court to reverse those things? If you stay an order, you suspend execution order, you postpone date of possession, those are all words which it might be thought carry with them by implication the power to reverse them.
That must be right.
Yeah, thank you.
Well, the only other point I was just going to draw briefly your attention to is the judgment of District Judge Bell, when she deals with, pretty just for the sake of completeness, with the other allegations.
I'm going to DJ Bell.
Yes.
Right.
To get
Yeah.
Yes, page 84, paragraph 9. In respect of the allegations in 2020-2021 regarding noise, in her witness statement, she has sought to explain where some of the noise may have come from, and I accept the matters that were set out in Miss Marrick's witness statement on a number of occasions lacked any precision, there being no written evidence to back up the matters set out and reported by resident A. And then Miss Kerr set out her explanation. So she declined to make any findings of the facts. Well, unless I can assist you any further,
Thank you very much. Well, thank you all very much for your submissions. Very economical. I think we had another day so apart from this, so congratulations for finishing within a day. We will reserve our judgment. You will get draft judgments in due course, probably in relation to both appeals rather than a separate judgment for each. That will be your chance to look at the way we have expressed ourselves, correct any typographical errors and so forth, but not raise new points or re-argue the case. The draft judgment will come with a strict embargo, which restricts its distribution to those on the list, which has already been given to the court. That embargo is strictly enforced. In the light of the draft judgments, we would hope that you will be able to agree an order or orders disposing of these two appeals. But if you can't agree the requisite forms of order, please make short written submissions and we will make the orders that we consider to be appropriate. Thank you very much.
If I may, can I correct what I told my lords this morning about court fees?
Yes.
So at the time this claim was issued, the claim fee was £355. At that time, the application fee was £275. So a difference of £80. Now, both those figures are different. So if one is now to issue a possession claim, the fee's £391. And an application now is £303, making a difference of £88. And I told the court it was £52, but in fact it appears to be £88.
All right, thank you all very much.
Sorry, my lords, also, just before the lunch journal, my lord, in my learned friend's response, you indicated that I hadn't taken you to the relevant passage in Hansard's that we relied on, but it's in my skeleton argument, and I didn't feel that I needed to, but for reference, it's at paragraph 35 in the skeleton at pages 53 to 54, and the extract in the miscellaneous material is at page 512. And I did, given that it was in the skeleton and we'd had a haggle about it, if I can put it like that, I didn't feel it was necessary to actually take you to the passage.
Thank you very much.
Court rise.
Thank you.